and I'd like to welcome you all to our second webinar in our legal information series. And this one is going to be on capacity to consent. Bear with me for a minute if you already know this information, but because people are coming in to do the webinars, they might be coming into different ones, they're not a series. I want to give a little bit of background. So if you already know this, bear with me. We are Communication Disabilities Access Canada. We're a non-profit, Canada-wide organisation, and we have been working on various social justice projects since 2001. Our mandate is to promote human rights, accessibility and inclusion for people who have speech and language disabilities. I use that term throughout. The trainings and on our website we use the word speech and language disabilities because in the world of accessibility they tend to understand that more than communication disabilities. So speech and language disabilities, and we include people who use augmentative and alternative communication. We work on time-limited projects, and we are a group of speech-language pathologists, AAC clinicians, legal professionals, access consultants, and always included in our projects are people who have speech and language disabilities. If you're not familiar with our organization and our various projects, then I would really ask that you recommend that you visit our website and go under projects, and you'll see a range of different things that we have been and are working on. We are grateful to the funder for this webinar series. They're funded through the Law Foundation of Ontario and through the Connecting Communities program, and that is operated by Community Legal Education Ontario. And special thanks to Catherine Hunter from the LFO and to Vivian Green from CLEO for this. It's very important that you realize that we have participants from all across Canada, from 6 provinces, and we also have a very diverse audience for these webinars. We have speech-language pathologists. We have people with speech and language disabilities, and I see a few that have signed on this evening, which is wonderful. We have family members. We have lawyers. We have social workers, we have healthcare providers, and we have students. So lots of different people coming from different perspectives, but all interested in these topics. So I'll be very upfront with you. We're not going to please every one of you within an hour and 15 minutes on these topics. What we're trying to do is start the conversation, and I think what we have are the right people around the table for these discussions. So I'm very excited by this. And our presenters this evening, I'd like to welcome Brendan Poran again. Brendan is a lawyer working with us on this series. And Brendan is with Poran Law here in Toronto, and he specializes in legal services for people with disabilities and their families. We also have Megan Hines, who's an occupational therapist, and Megan's worked with me on a number of CDAC projects. She works specifically with young adults with disabilities and with chronic health conditions, and most of her work is in relation to helping families transition from home into community settings. So we're delighted to have Megan with us this evening. I'm Barbara Collier. I'm the Executive Director of CDAC, and I manage all of our projects, and my background is speech-language pathology and augmentative communication. This series, as I said, is really focused on legal information. It's funded by the Law Foundation, and the whole onus and the focus is on the legal information. However, we believe that you cannot just give legal information without also addressing how you communicate about your legal rights in these situations. So we're trying to balance this with here's the law, here's what should be happening, here's what you can do when it doesn't happen, or perhaps, and then also here are some resources that are out there to assist people communicating about these topics. In an hour and 15 minutes, we are not going to get it all done. These are full day, full week sessions, but as I say, a good start. After the webinar, we'll be sending you the handouts tomorrow. The webinars are also being recorded. The recordings will be available through a link on our site until June the 30th. The handouts, we are only going to give you the resource handouts. We're not going to be giving you the slides as handouts. I know that a lot of people are going to be really upset about that. So unless it's an accessibility accommodation, we're asking people to actually attend these webinars to hear the information rather than just taking the slides and thinking they have everything they need there. And this also reflects the requirements of our funders, that people have to actually show up to these trainings or take the recordings. The series, last week we talked about access to goods and services. That will be archived towards the end of this month. We'll send that link out to you, and it'll also be on the website. Today's is consent to treatment. Next week, we're talking about substitute decision making. On June the 1st, personal support services. And on June the 14th, please note that this is a Tuesday, not a Wednesday. Pamela Cross will join us to talk about abuse and crimes within the caregiving context. Just to give you some background, all of our information this evening is grounded in reality. Megan has interviewed, done surveys with speech pathologists as well as people with speech and language disabilities, collected real stories and real questions, and that is what we have designed the webinar around, those issues. We are going to be addressing Ontario legislation. I see that there are people from other provinces on this webinar. Bear with us, that is the focus. However, a lot of it should be applicable in other provinces. And even if it isn't, at least it gets you thinking about that and asking the questions in your areas. We will be giving you some resources. Please type in your questions as we go along, or wait till the end. It's probably wise to wait till the end. Promise to give you some time at the end for that. And we remember too that we are recording this, so be careful about mentioning names and private information, confidential information. Today's agenda: legal information about capacity to give consent to treatment. It's an enormous issue. We are going to be focusing on people who have capacity, but who have speech and language disabilities. And even if they have the capacity, they experience significant barriers in this situation. Next week, we will be talking about substitute decision making, but we're actually talking this evening about people who have the capacity and still experience significant barriers. And I know many of you are very familiar with those. We're going to talk about, Brendan's going to explain the legal information, what should happen. We're going to give you some suggested protocols and accommodations very briefly. We're going to talk about the role that speech language pathologists can play in these situations, and then get to the experiences and of people with speech and language disabilities, and have Brendan respond to those. Just to frame this webinar, I want to make sure that we're all on the same page here. We know in discussions with people with speech and language disabilities that it is a recurring theme that they are often denied autonomy, denied opportunities to make their own decisions and to exercise their autonomy. Nowhere is that more critical and more apparent, I think, than in healthcare settings. So we're not going to solve this evening, but what we want to do is share with you the recurring experiences that people seem to have. And we need to know that in order to anticipate what might happen, and in order to empower them and the facilities, the healthcare facilities, to ensure that they are able to communicate consent to their treatment. So basically using this to say, well, what do we know about this and what actually needs to happen? What we're talking about is about giving informed consent. In other words, in healthcare, and we're focusing on healthcare this evening, is basically giving someone permission to do something that impacts on you. And this involves being able to understand the information that's being given to you, being able to retain the information and appreciate the consequences of the options, and being able to communicate one's decision about the consent. We know that people with speech and language disabilities can experience difficulties in any of these areas and may require communication accommodations in order to understand information. Think about people with aphasia who have difficulty processing information auditorily. They may need accommodations to understand it. They may need other people may need accommodations to retain information as part of the decision-making process. Think about people with cognitive linguistic disabilities or early dementia. And we also know that many people have difficulty communicating their decision accurately and authentically to a healthcare provider. So accommodations may be required for people with speech and language disabilities in these areas. In addition, there's a subset of this group. There are some people who have speech and language disabilities, not all people with speech and language disabilities, who may also require accommodations to make the decisions because of cognitive challenges, reduced attention span, limited problem-solving skills, limited experience making decisions, and limited life experience. So accommodations not only for speech and language disabilities, but also then accommodations in decision making itself because of speech and language disabilities and because of these factors here. We also have to consider the context that people are being asked to give consent in. And we know from talking with people with speech and language disabilities that many healthcare professionals have no difficulty with this, but many do. There are perceived presumptions about the capacity of people with disabilities, and specifically people with disabilities who have speech and language disabilities. There may be people who make these decisions, make capacity decisions, often have no training and no experience communicating with people with speech and language disabilities, or they may have experience with one disability type. And I can just imagine all the speech paths out there just nodding and saying, well, we know this, we've been there, this is every day, we talk about this. But we also have very few, or I would say no, protocols to guide healthcare professionals in identifying people who have speech and language disabilities and in the provision of appropriate communication accommodations. And I want to talk about this later on in the webinar. The consequences can be very critical. And it'll be interesting when Megan tells you the stories and the questions that we got in our surveys and our interviews, recurring over and over. People presume lack of capacity due to communication disabilities. Consent may not even be requested in the first place from a person who has a speech and language disability. They can be ignored. And people, healthcare professionals, turn and ask consent from somebody standing beside them, be it a family member or even an attendant, a staff person. We've heard time and time again that no communication accommodations have been provided and no accommodations for decision making. We also know that decisions may not be acknowledged. We have stories of people who have clearly given their consent or their refusal for treatment and have been ignored for that. And And all of this, we know, can have significant impact on health and can lead to death. We are right now in negotiations and discussions with the Ministry of Health over physician-assisted dying and the importance of being able to communicate within those situations as well. Now I'm going to turn it over to Brendan, who's going to provide us with a legal framework for this. Brendan, are you there?
I am. Thank you very much, Barbara. And that was a great introduction to the topic. Good evening, everybody. As Barbara mentioned, I'm going to provide a legal framework that sort of explains the area of consent capacity and legal decision making. To start off with, I want to emphasize the fact that sort of re-emphasize what Barbara has already mentioned, and that is that when it comes to legal decision making, this really is a two-step process. The first step being, is the person capable of making their own decision? And if so, it is the person's right to make their own decisions. If not, if the person is deemed incapable of making a decision with regards to healthcare treatment, admission to a care facility, or personal assistance service, only then is consent sought from what we call a substitute decision maker, and we'll get more into SDMs in the webinar next week. So again, I just want to emphasize that if the person, if you are capable of making your own decision, then it is your right to make that decision. So in terms of speaking about capacity and how we sort of define capacity, I'm gonna read what we have on the current slide. Slide number 14. A person is capable with respect to treatment, admission to a care facility, or a personal assistance service if the person is able to understand the information that is relevant to making a decision about the treatment, admission, or personal assistance service, as the case may be, and able to appreciate the reasonably foreseeable consequences of a decision or lack of decision. So what this really reflects is what we call a cognitive test of capacity, and the two underlying themes here relate to the ability to understand the information related to making a decision and the ability to reasonably reasonably appreciate the foreseeable consequences of that decision. So when we talk about understanding, we're talking about does the individual generally understand? Do they have that sort of the cognitive capacity to understand the let's say the nature of a particular type of illness or the nature of a particular type of treatment? When we talk about the ability to appreciate the reasonably foreseeable consequences, we're talking about, can the individual apply that information to themselves? Can they weigh the risks and benefits of treatment? Do they appreciate the fact that they may have a certain type of illness or mental disorder? Can they apply it to themselves? So in order to sort of be deemed capable of making a treatment, an individual must pass both branches of that test. Branch 1, which relates again to understanding, and branch 2, which relates to the appreciate test. In Ontario law, we have what's called a presumption of capacity. So the law begins with a presumption of capacity unless evidence raises the question of capacity and a decision has to be made. So many people often sort of reverse this, and we see this happening with third-party providers as well, where somebody may notice that an individual has a sort of a visible disability and may presume incapacity. But the law actually states that there's a presumption of capacity. So everyone is presumed to have capacity unless there are some circumstances or some facts or some evidence that raises this question of whether or not somebody's capable of making a decision, and a decision has to be made. So for example, somebody is in a doctor's office and is being prescribed medications. A decision has to be made. Consent has to be given to that treatment. But if no decision has to be made, there's no reason to go out and seek any kind of capacity assessment to find somebody incapable of making that decision. Okay. Capacity is for individual decisions in healthcare. You can be capable of some decisions that are simple, such as taking antibiotics, and not capable of others, such as decisions that may be more complex in nature that speak to surgery. So, um, I think just sort of taking a step back for a second, there is no kind of global finding of incapacity or incompetency, as some people refer to it as. I can be perfectly capable of choosing where I want to live, let's say, but not necessarily capable of making a decision related to my surgery. So, capacity is very individualized in nature. And it's also important to note that capacity is not a static thing. A person may be deemed incapable today, but capable a month from now of providing consent to treatment, and this is very important. Typically, if someone's found incapable of consenting to treatment decisions, they have a right to appeal that finding every 6 months, given that capacity is not a status thing. So just because an individual may be found incapable at a certain point in time, it doesn't mean that that finding is in place forever. And capacity is determined by the person providing the service. And I guess, in terms of speaking about healthcare decisions in particular, if an individual is interacting with a healthcare practitioner, and the healthcare practitioner requires consent for some sort of treatment, then it's really up to that healthcare practitioner at that point in time to assess whether or not the person is capable of making a decision or not. Um, if we take this just an example outside of the healthcare context for a second, if someone goes to see a lawyer to draft a will, often it's the lawyer that's assessing whether or not the person may be capable of drafting the will. It's a little bit different because the lawyer's finding there isn't necessarily binding by any means, but the point here is it's typically the third party that the individual is interacting with that is determining whether or not he or she is capable of making that decision, unless a formal capacity assessment has been made and a substitute decision maker, namely in the form of a guardian, has been appointed to make decisions for that person. And we'll get a little bit more into substitute decision making next week. In emergencies, you can be treated without informed consent. So, for example, if you're unconscious or if you're suffering or dying and you not receive care immediately. So this is the sort of the one situation where informed consent is not required. So a healthcare practitioner can move forward and treat you without your consent or the consent of a substitute decision maker. And assessed capacity can vary according to the supports provided. So the point here is that if there are a lack of supports in place or lack of accommodation in place, then if someone has let's say a communication barrier or some sort of other obstacle to demonstrating that they're capable, that could affect the outcome of a capacity assessment or healthcare evaluation. Okay, there is a duty to provide access accommodations that the patient may require to give consent. So, I mean, this is a principle that's embedded in our Human Rights Code, and we spoke of the duty to accommodate in last week's webinar. So, for example, giving the patient a means to communicate through perhaps some sort of assistive device, ensuring the healthcare provider knows how to communicate with the patient. So, somehow sort of informing the healthcare provider in advance that a communication device is going to be required, or a support person may be attending with the individual and providing communication assistance when required. Even though the duty to accommodate is already embedded in our legal framework, if anyone has read the interim report on our alternatives to guardianship that's been put forth by the Law Commission of Ontario, they've actually recommended that the duty to accommodate be even more clearly identified within consent and capacity legislation. So, this concept is very, very important. An individual should never face any kind of barriers in terms of demonstrating the fact that they are able to understand and appreciate information that's related to the decision-making process. So what should happen? The provider should know how the person communicates and what communication access accommodations they may require, and we've sort of touched on that a couple of minutes ago. No capacity decisions should be made without considering the person's need for access accommodations. And again, just reiterating the point that all providers have a duty to accommodate individuals and provide whatever means is necessary in order to allow the person to demonstrate the fact that they are able to make their own decisions. The patient should be consulted first, whether or not the provider ends up deciding that the person is not capable of giving consent. And this speaks again to the presumption of capacity. So, a healthcare provider should not just simply look at somebody and decide arbitrarily that this person is incapable of making decisions in terms of somebody else. There should be an effort to consult with the individual patient first. There should be a means of accommodation provided if necessary, and based on the interaction between the provider and the patient, the provider is ultimately going to decide whether or not the person is capable of making healthcare related decisions. And the person should have the opportunity to ask and answer questions. So, I mean, as part of the assessment or the evaluation process, a healthcare provider should be asking the individual questions. Otherwise, it would be very difficult to assess whether or not the person is actually capable of making their own decisions. The provider should tell the patient if they think he or she is capable before speaking with a substitute decision maker. And again, this just speaks to the point that I just made. Remember my earlier sort of the first point I made when I started speaking around sort of the two-step process. Capacity comes first before you seek consent from a substitute decision maker. So it's imperative that the healthcare provider evaluate the person to decide whether or not he or she is capable of making a decision before speaking with a substitute decision maker. And if the person is capable of making their own decisions, then the individual, the patient, has the right to decide whether or not they want anybody else in the room with them. So they may not want a family member present when the doctor is examining or consulting with them, and they've got every right to request that the family member be excluded. Family or staff supporting the person cannot make healthcare decisions on the person's behalf. So the point here is that if the person is capable, then the family has no legal standing whatsoever. If the person is incapable, and again, we'll get into this next week, the family member may have some legal standing to step in as a decision maker. Staff supporting the person do not have any kind of legal standing when it comes to making healthcare decisions on the person's behalf. The provider explains all the information needed to make a decision to the patient in a way that the patient understands. So this speaks to the duty to accommodate. So if the individual needs a little bit more time to process the information, if there is an alternate means of communication that is required in order for the person to give the person the opportunity to understand the information and to appreciate the reasonable foreseeable consequences, then again, it's imperative that the provider accommodate this process. The provider checks to make sure the patient understands what the treatment and assessment entails. So, I mean, when the provider, kind of begins the consultation, begins the evaluation, they should sort of understand, they should sort of explain to the patient what they are about to do, why they're about to ask, a number of questions and what the purpose is of the evaluation. If the provider has reason to question capacity, they ask more questions to determine if the patient understands. So, I mean, again, this is just all part of a proper evaluation process. So if there is reason to doubt the person's capacity, then the provider should probe further. If capable, the patient decides, and we've emphasized and re-emphasized this over the last few minutes. If not, the provider tells the patient they believe they are not capable, explains the option of appealing, and tries to locate the highest ranked substitute decision maker to make the decision. So again, if the person is deemed incapable, then the healthcare provider would seek consent from an SDM, a substitute decision maker, and we'll get into substitute decision makers in next week's webinar. If the decision is not appealed, the provider seeks consent from the substitute decision maker, and the provider repeats all the above steps with the new decision maker to ensure that the SDM, the new decision maker, is able to understand the information relevant to making a decision and reasonably and has the ability to reasonably appreciate the reasonably foreseeable consequences of that decision. No informed consent without the provision of required communication accommodations. And again, we've spoken about this already. Individuals should have every opportunity at their disposal to demonstrate the fact that they are capable of making decisions. So barriers to accessibility should not render the person incapable of making their own treatment decisions. And back over to you, Barbara.
Thanks, Brendan. Thank you very much. That was very interesting and a good framework for understanding our role in this. I know we are, I'm so glad to be hearing this from a lawyer saying that no informed consent without required accommodations. We know that that's not the reality, but that's exactly where we need to be right now in our discussions. I wanted to talk a little bit now about what's happening here in terms of how we see the role for speech language pathologists and all of this. We know that in Ontario, speech language pathologists can get informed consent or are responsible for getting informed consent for their own treatment, and that also they can be involved in consent to long-term care and personal support services. They may or may not, we may or may not be involved in other consent to treatment situations. And I know that this concerns a lot of people who feel that they every day hear stories about patients and people with speech and language disabilities in these situations without the appropriate accommodations. So I think there's a number of things coming out of this that that can define a role for speech language pathologists and that we need to start the discussion about. First of all, in preparing people with speech and language disabilities and their families about communicating in consent situations. So, for example, we are suggesting that when speech pathologists write their reports, just the same way as we mentioned in last week's webinar, we should be documenting what potential accommodations this particular person may require in certain situations, and specifically in situations around consent to treatment, because that may be the only report that a doctor or a lawyer might read, and that needs to be very clear. This person may require assistance from a speech language pathologist or a communication intermediary or a trusted person to assist them communicating. We also see an enormous role for speech language pathologists educating healthcare providers about when and how to provide accommodations. And we see a role, we would advocate, along with CASLAPO, that speech language pathologists should be able to conduct capacity assessments and also should be involved in providing communication accommodations. I know I've had this discussion many times with my colleague, Elise Shumway. I know she's on the webinar. And Elise will say that she would prefer to be the intermediary to assist somebody to provide the accommodations and to have somebody else conduct the assessment or to obtain consent to treatment. But because it's very difficult to wear both of those hats, and in some cases it can be a conflict of interest as well. One of the things that we have also made some recommendations. Interesting, Brendan, that you mentioned the Law Commission's report, the interim, I think it's a draft report at this point, on legal capacity and guardianship. We have read that. We have made a number of recommendations to highlight accommodations for people with speech and language disabilities because they really weren't very clear. In fact, they were omitted. And we would like to see things in place for them. We have, with that in mind, I'd like to share with you a protocol that we as CDAC have provided around, this was provided to the Vulnerable Persons Standard, which is a standard to safeguard people, a proposed standard to safeguard people around doctor-assisted dying. And we put a lot of thought into this. It's not rocket science, but we wanted to put it all down as to what we thought the protocol should be. And I'm sharing it here because I think, in fact, the protocol could apply to all consent situations. And I'm going to read it to you. Effective communication is essential for all patients when providing informed consent to treatment. Successful communication is a two-way process in which messages are correctly and unambiguously understood by the patient and the physician. In this case, we were talking about assisted dying. If there is any question about the communication process, as identified by either the physician or the patient, note that there's two in there. It's not just the physician, it's also the patient. If there's any question of the communication process, then a neutral, independent professional with expertise in the patient's communication needs must be engaged in order to assess the required accommodations and/or provide direct communication support. Communication accommodations include, these are just examples, picture or letter boards, speech output devices, hearing aids, or communication assistance from a speech language pathologist, a sign language interpreter, an oral translator. There's a couple of things in that protocol that I think are really important. We're saying if there's any question, stop, something has to happen, that can be identified by the physician or the patient, because we know that we've heard some people with speech and language disabilities telling us that the doctors don't even think there's a problem. The nurse thinks she's great because she's just guessing what I want. I think there's a problem, but they don't think there's a problem. So it has to be flagged by either one of them. And that the accommodations must be provided, must be the assessment part must be done by a professional with expertise in that particular disability. If the person is deaf, sign language interpreting. Deaf-blind intervener. Speech and language pathologist. So we're looking at, we will define with the person with the speech and language disability what the accommodations are. We don't expect that every doctor, every healthcare provider will be trained in everything. I want to give you an idea of what accommodations we're talking about, because sometimes I think when I talk to people outside of the speech and language disability community, people think it's just about finding someone who's very nice. And it's more than being polite, and it's more than being nice. So for instance, an accommodation for understanding, I actually spell it out now. Speaking in everyday language, lack of jargon. And we know that the greatest offenders are the ones who don't even know they're using the jargon. personalizing the language, making it relate to the person. On Monday, that's the day you go swimming, to help people understand that that's what we're talking about, the Monday. Generic strategies for support, like pacing the communication, sentence length, all of that. Visual aids, use of pictures, talking maths, communication aid for capacity evaluation developed by Alex Rowland. All of these things that are out there, we know where to find them. We know how to use them. And if the person has aphasia, I'm talking about supported conversation for people with aphasia. So bringing to the table our skills at that point. In terms of retention and problem solving, we know a lot about memory books, visual aids. We also know that for people who use augmentative and alternative communication, that there's a problem solving model that has been, are we okay? I'm getting some, okay, that has been used, evidence-based, with people who use augmentative communication to assist them problem solving. It wasn't developed by Janice Light, but it was adapted for use with people who use AAC. We will be giving you handouts with references for that. But basically, it's helping the person describe the problem or the question, outlining all the different alternatives with them, helping them identify the consequence, and then taking action. And of course, then we're looking at accommodations to help people communicate authentically and accurately to another person. That may be giving them the means to communicate, the vocabulary, knowing where to find the vocabulary that's already been researched, knowing how to do vocabulary selection, not just thinking it out of the top of your head, knowing the strategies of echoing what the person is saying, reformulating and validating their message. We do a lot of these, we share this information through for speech pathologists, through our communication intermediary training program. And we will be running, we have a roster of speech language pathologists who are trained in communication intermediary services for justice. Many of them have applied these skills within consent and capacity situations. If you're interested in that, email me. We will be running some more trainings, the webinar series, and again, it's for speech language pathologists who work as intermediaries. We'll be doing that in September. Certainly send me your email and your name way ahead of time. Then the other whole thing is, so the types of assistance then coming from an arm's length professional. I'm not going to turn it over. So that was very, very brief. But it was just to sort of give you the broad brushstroke of things. So what I would like to do now is turn it over to Megan with some of the questions and experiences that she has had from her interviews with people. Megan, are you there, Megan?
Hi, good evening, everyone. So I'm here. Can you hear me?
Yes.
Can you hear me?
Yes.
Uh-oh. Oh, here we go. So I just wanted to thank everyone who shared their stories. First of all, by far and away, this was the most common topic that people wanted to discuss. And the same themes came up over and over and over. So we can't capture all of the stories that were disclosed to us, but hopefully we can capture the key main points. And this first one is one that we heard from universally, almost everybody reported this, that healthcare providers won't listen to you, that they talk to whoever you are with. And the stories included not just family members, but group home staff, attendants, and particularly in eMERGE and ICU settings. So I was going to have Brendan respond to that.
Sure. So with regards to healthcare practitioners or healthcare providers, again, remember that the first step is always determining whether or not the individual is capable of making their own decisions. So again, it's incumbent upon the provider to assess or evaluate whether or not the person is able to understand the information that involved in making the decision and whether or not they're able to appreciate the consequences of that decision. I mean, that's the law. They have to do that. If they don't, and I often, not, I shouldn't say often, I do sometimes see the first the capacity sort of assessment skipped. You want to do everything that you possibly can to ensure that you are given the chance or given the opportunity to demonstrate your capacity. So that may involve carrying a letter with you, or carrying a note, or carrying some sort of communication device, or support person to assist with the communication piece.
And just from my own experiences, I think that in many cases, the providers may or may not have very much experience interacting with someone with a speech and language disability, and often automatically assume a cognitive disability, whether or not that's accurate or not. And so again, as Brendan was saying, the more you can prepare in advance and have some way of communicating and planning ahead for these situations, whether that's a card in your wallet or a doctor's note, that can help in terms of getting the provider to sort of think twice about making an automatic assumption, especially if they're in a time pressure environment like the ER. So the next one, I'm just advancing the slide here. Yeah, so this was another one. People feeling like they didn't get enough information or have enough time to process the information. So this was an example that came up several times, this specific one. The doctor tried to explain the G2 procedure. It was a complex process, and I don't think Dee understood what he was saying. He didn't check to see if she had understood or had any questions, and when he finally asked if she understood, she just nodded, but I think she was very overwhelmed and confused. So I'll have Brennan respond to that.
Yeah, so I mean the same principles apply. I mean, again, the doctor in this situation has a duty to accommodate the individual's needs. If you are unsure or you feel overwhelmed, I know you could quite easily sort of feel a bit pressured that you have to make a decision right away, and that's simply not the case. I mean, there's a duty to accommodate. You can take your time. If you need things repeated, ask to have things repeated. Again, the more prepared you are in advance, the better. So if if there's a way of informing the doctor that you need things in plain language, or you need them to sort of take their time with regards to explaining things, that would go a long way.
Right. And I think in some of these circumstances, the physicians themselves are feeling a lot of pressure from the organization or from the family, or a sense of obligation to treat as soon as possible. And I think there are some improvements. I work at Sick Kids, and I do see some attempt to take a step back and look at how urgent the nature of the situation is, and look at the consequences of not making an immediate decision, and working to provide more time and space for these accommodations, and also trying to increase awareness about how to cascade out for more supports or referrals to help in these types of situations. So asking if there are speech and language pathologists available, or trying to gain more support in the context that they're in. But I do think that for many of these circumstances, it's not the average patient that they're coming across, so they're unfamiliar with the circumstance to begin with, which is part of why this can occur.
Yep.
So
that makes sense.
Yes, so this came up a lot, and I heard this a lot from people with disabilities themselves. When the person has family around, the doctors will typically turn to the family member and ask them for their consent. They often assume that the person with communication disability cannot make or communicate the decision, and that the family always has the person's best interests at heart. A lot of people who are more middle-aged, it was often a sibling that they may or may not get along with that would end up having made decisions for them that they didn't necessarily want made. So that was one that came up quite commonly as well. So Brendan?
Yeah, again, same principles. So if you are capable of making your own decision, then it's your right to make that decision. It's also your right to exclude any family members from interacting. You know, it's your right to like in order for other family members to be privy to your personal health information, you also have to consent to that. So if you don't want information shared, then it's your right to inform the healthcare practitioner to not share any of this information with family members. Some of the same advice that we spoke about in the last couple of scenarios. You know, if you do come prepared in such a way that you know you do have the opportunity, just like everybody else, to demonstrate the fact that you are capable. I think that would also go a long way. Remember, if the healthcare practitioner is seeking consent from somebody else, from a family member, they're effectively finding you incapable of making your own decisions
Yeah.
with regard to that healthcare treatment. And so there is a right to appeal that as well.
Right. And I think there's a difference between sort of routine and predictable circumstances, like a specialist appointment that you knew was coming up for months in advance, where you may have the opportunity to send a letter or to talk to the person in advance. And a lot of these circumstances come up in unpredictable. So they went into the ER, they're admitted to the hospital, and the family member just sort of turns up and starts making decisions at the nursing desk. So that's kind of the story that we heard a lot about. And then the other thing to note is that we will be talking about substitute decision makers next week. And if there are family members that you do want to exclude, we will be talking about power of attorney and legal options next week in that webinar as well, for situations where you actually are not capable of making your own decision, but you do want to make sure in advance that you know who is going to be making those decisions on your behalf should you become incapable at some point.
I just want to jump in there, Megan, for a minute and just say that while we talk about this, it sounds easy, but it is incredibly complicated because these are people and these are family relationships, and very often people who are disempowered anyway, having to negotiate these situations with family members. So I want to make sure that we realize that this is not at all easy, but it really seems to me that that conversation needs to happen with people without family members there, or with them. It needs to be negotiated, and some people will need help with this. Would you agree, Megan?
I would agree 100%. So we did hear a lot from service providers who interact with a person with a disability every day and then have a family member come on to a situation that hasn't been in contact with that person for years. But these are complicated relationships, and it's very difficult for the person who has the disability to sort of go against a family member's wishes sometimes, or assert their own beliefs and their own wishes, and oftentimes will later say, you know, that went down in a way I didn't like, and there's a lot of time pressure sometimes in these decisions and how they're being made. So one of the things that I think kind of came out of this for me is that patient education is really important in terms of what conditions they have and what the prognosis and likely complications are, so that people come into some of these situations a little bit more prepared as to how they feel about different options and what they would like to have happen.
Yeah. And I see a role for speech language pathologists in this, because very often people feel comfortable communicating with us, and because we know how to communicate well with them, hopefully, and that we can often play that role around this if we know that we should be doing it and we should be assisting them negotiate. I feel it is a role that we can play.
I agree, and I think the writing of accommodation requests and using that specific term, since there already is sort of a legal construct around that, is a great starting point. So I'm going to go to the next slide, and then I will get to the questions that are popping up in the chat box when we're done this. So medically assisted dying. So again, this came up. It's a concern within the community. So many people with speech and language disabilities are concerned about doctor-assisted dying. They fear that doctors will not understand their wishes and defer to family to make decisions for them. Does the law protect people who have speech and language disabilities when communicating about end-of-life decisions? And just to put context on this, I think specifically many people had concerns that when doctors see them, they see someone with a severe disability and make an assumption that their quality of life must be very poor, and are kind of lean more towards not providing interventions that people with disabilities would like to have provided, and maybe not consulting the person with a disability themselves because of a presumption of incapacity. So just to put context on what the theme was with some of the stories behind that. So Brandon.
Sure. I mean, yeah, this is sort of a very kind of complex question. Barbara did a great job in going through some of the protections in the vulnerable person standard that that will sort of hopefully protect against this. I don't anticipate that we're going to see legislation that actually allows a family member to consent to, doctor-assisted dying. But that being said, I mean, these situations come up every day outside of the sort of the doctor-assisted dying context when we're talking about end-of-life decisions generally, right? So if you're in hospital and you've got a serious condition and you're going in for an operation or whatever it is, the hospital is generally going to want to know whether or not, let's say, you want to be revived or on life support, or depending on the outcome of the procedure, if something goes wrong. Megan alluded to the fact that we are going to be speaking about substitute decision making next week and powers of attorney, but here is where powers of attorney are very, very, very important, because you would, in these documents, you would have the opportunity to articulate what your wishes are. And your substitute decision maker, your attorney for personal care in this situation, would be legally obligated to adhere to those wishes. Right. So I'll sort of leave it there, and we'll sort of get into that in a little bit more detail next week.
Okay, perfect. I'm going to move on so we have time.
If I can just jump in there for 1 minute. That was only our accommodations were recommended, and we presented it to the standing committee, a justice a couple of weeks ago. I know that the federal government is still working on legislation, but there is nothing that I have heard at all about somebody else making a decision for somebody around doctor-assisted dying. It must come, they must be fully capable, and they must be able to communicate their own wishes. And I think that that's the way, as far as I know, Brendan, I think that that's how it's going to be rolled out at this stage anyway.
That's absolutely right.
Okay, so
that's absolutely right.
I'm aware that some people were very worried that family members could basically tell doctors that what to do around this, and I just want people to be assured that that cannot happen the way the legislation is right now at all.
Okay. Okay, I'm going to move on in the interest of time. I know that this is sort of a hot topic. So. Children and young adults, I get this question all the time. What is the age of consent for children, and what happens if there's no agreement between a parent and child about treatment?
So there is no age of consent in Ontario. That's really the bottom line. Doctors would be assessing children for capacity as they would everybody else, and they would be taking into account the child's age, the child's level of maturity, and the type of treatment that's being proposed. There doesn't need to be an agreement between child and parent if the child understands, and if the healthcare practitioner is satisfied that the child has capacity, then it's the child's decision to make.
Right. And I would add that at SickKids we use something called the shared management model, which means that over time, as the child ages, they take on more and more responsibility for managing their own care and making decisions. But it also means that they can include their parents to whatever degree they want to, even if they have capacity to still support them in decision making. So that is kind of the model that's being used at SickKids. And again, obviously, the two sort of indicators of understanding the treatment that's being proposed and appreciating the consequences, and the fact that we know that capacity isn't static and sort of develops over time, and that we work towards patient education to try and get them to that point.
And I think the other piece there, Megan, is remember that there's a presumption of capacity as well at age 16.
Exactly. Yeah.
So
Yeah.
yeah. So at age 16, the law presumes that we're all capable of making our own treatment decisions.
Yeah.
As a starting point. Mm-hmm.
Okay. All right, so some people need support not just to communicate their decision, but to actually make a decision. They may have little or no experience making their own decisions, or they may have difficulty thinking through and weighing up the options and consequences of different decisions. What can we do to support people in these situations?
Mm-hmm. Well, it's a great question. I mean, and we spoke, I think, a little bit about this last week as well. Unfortunately, we don't have any sort of what we call a supported decision-making legal framework here in Ontario. That being said, I would encourage you to frame the support as an accommodation, right? So if with support, the individual can get to the point of being able to understand the information and appreciating the consequences of making a decision, then I would try to make the case to the third party that the person is capable of making their own decision.
Yeah, and
We would like to see, yeah.
Oh, go ahead.
No, sorry, Megan. I was just going to say we'd like to see some reforms, within our legislative frameworks to recognize supported decision making, and it's something that a number of groups and a number of people are actively kind of advocating for here in the province.
Yeah, and my experience has been in the hospital that people are very open to providing accommodations if it's proposed and suggested up front. But I think it doesn't necessarily occur to people in the moment that they could delay a decision or rebook more appointments to discuss further and provide more patient education or bring in additional supports for the person. But I have seen patients with mild developmental delay have additional accommodations and multiple appointments, and even some experiential learning, so getting tours of the new facility or watching videos about what a treatment would look like, to help them better understand what the treatment entails and what the consequences would be. So it can happen, and it does happen. But if it's not something that's planned out or requested, it may be something that's sort of skipped over, and in the time pressure, it may be you might move to a substitute decision maker without providing that sort of due process.
And I just want to add to that, Megan, to that point. This was a real aha moment for me in talking with Brendan about accommodations for our population. I had no difficulty at all with talking about communication accommodations, but I hadn't actually ever framed support for decision making as an accommodation. And I think that that's exactly where it should be, Brendan, and I'm really glad that you're highlighting this for us. I also think as we various groups explore supported decision making in Ontario, I think it's absolutely critical that they explore it with speech language pathologists and augmentative communication clinicians for this population, because these are language issues. This is cognitive linguistic, and to date, when I read about supported decision making, that's a huge missing element that I think we bring a lot of skills to the table, and we should know how to do this. I think it's an evolution of our role, but we should know there's a subtle difference, I've always said, between supporting somebody to make a decision and actually advocating for a decision and making a decision for them. We need to figure out our own boundaries around that. So I'm really glad that you're bringing this up.
Right. So
we have some questions.
Yeah,
Megan, sorry,
exactly.
I interrupted you, and I was going to, are you going to take the questions?
Sure.
Please go ahead, absolutely. I just want to before we go to the questions, tell people that there will be handouts.
Yes.
We're going to give you some consent to treatment legislation and in Ontario, tips for communicating about consent with a patient who has a communication disability that you can give out, and communication resources within a healthcare setting all around this topic. So we're going to do that. We'll send those out to you tomorrow, and we will also send you out a link to our survey. Please, we are offering these free of charge. We ask that you give us some feedback and tell us what you want more of, because it's really important, again, for us and our funders to know whether these are useful and whether you have more questions. So over to you, Megan, for questions from the floor. From the chat box.
So I'm going to go in order of the questions that kind of came in. So in these type of situations, this is Bobby, by virtue of a speech and language disability, the client is not able to advocate on their own behalf in terms of speaking out his or her concern if the healthcare provider is not asking for their input on a treatment decision. What avenues can speech and language pathologists take to help with the advocacy piece?
I'd like to address that, and then maybe you can jump in. I think we have talked about a few things that you can do. Number one, anticipate that there's going to be problems. Talk with your patient, with your clients. As Brendan said, have a card that explains that they make their own decisions. Get a letter from their doctor that says that, so that they've got those with them. So put in your reports what the accommodations should be. Talk to family members as well about their role in this. I would also think that there's a role for us. Advocacy is sort of a weird, I have a problem with that word. I think we should be educating healthcare providers. I think we should be giving them the protocol that we suggested, and you're very welcome to use that. It's on our website, a protocol, and we are certainly engaged right now in discussions with the Consent Capacity Board and with capacity assessors to actually try and do some training in this area. It's not happening yet, but we have a huge role to play. But I think that all of this is about what speech pathologists can do. Is there anything that you want to add?
Yeah, and I think in my own caseload, I would say in my own caseload that I have started writing letters to go along with referrals to specialists or things that are coming up, so that people know that the person may require accommodations, and doing that with my actual patients and sitting down with them to say, you know, would you like more time, and what exactly would you like the new doctor to do with you, and putting that in a formal request. To be fair, I have good relationships with the people that we're writing these letters to, so it's a bit of a cheat in that sense. But I think when you formally ask people what you would like them to do, it often clarifies what should happen in those circumstances. So I'm going to go to the next questions. We have time. Again, this is Bobby, and they're talking about a situation where a client had a lawyer refuse to assist the client with changing his will, and the client/wife were at a loss as to how to get a lawyer to reconsider his presumption of incapacity.
Do we want to get involved in that, or Brendan, or because we are focusing on consent to treatment in healthcare right now? Can we? I tell you what, if there's time, can we come back to that, or and just do the healthcare ones right now?
Yeah.
Because we are.
Yeah. So Elise, I know our timing. So Elise Shimwe, as some cognitive disabilities can be rather hidden when communication functions are well preserved, are you aware of any healthcare professional being sanctioned for presuming intact capacity incorrectly? So are we aware of any healthcare professional that has been has had anything punitive happen for presuming that a person is capable when they are in fact not capable?
I mean, I don't know that I can really speak to that. You know, anytime a healthcare practitioner goes to administer treatment, an assessment needs to be done, an evaluation as to whether or not the person's able to understand and appreciate needs to be done. So you always do start with a presumption of capacity, unless, again, there's evidence to suggest otherwise, and a decision has to be made. So I don't know if there have been cases in the past where a physician has accepted consent from the individual, and it was later found that the individual was in fact incapable of granting consent. I'm not sure.
So I can answer that question from the sense of that the colleges are responsible for monitoring regulated healthcare providers. So the College of Occupational Therapists of Ontario, the Speech and Language, it's CAL. Oh, I'm not sure what the actual acronym is, but each of the colleges is sort of responsible for monitoring their members. So I have heard, because the colleges post publicly any hearings that do happen, I have heard of people sort of receiving complaints to the college about this type of thing, where the college will recommend remedial training or support for the person that did it, or if you have a review or an audit, like the College of OT will go through to ensure that capacity and consent are being documented appropriately, and they do random audits of their members. So I think it's how that's handled with each individual college sort of varies. But in terms of a legal sanction, I don't think I'm aware of anything on that. Okay. We don't have any further questions written in the chat box.
I think we have a few people typing.
But I'm just checking to see if anyone has anything.
Yeah. Shirley is saying, how does one appeal a decision? Brendan, can you address that?
That's a great question.
Are you talking about it next week? What do you think?
Yeah, I mean, I can touch on it here. I mean, so a person would have the right to appeal a finding of incapacity to the Consent Capacity Board, which is an adjudicative tribunal that is sort of provincially. It's an Ontario-based tribunal that is responsible for adjudicating applications of incapacity among other things. So it would be a matter, if you'd like more information in terms of how you'd go about doing this, I'd encourage you to go to the website of the Consent Capacity Board, and there are all sorts of information sheets and application forms, I believe, available on the site.
I think we give them next week, if I'm...
Oh, okay.
I think we do give some of those resources, Brendan.
Okay.
The question is...
And I see that Gail Fisher-Taylor is typing a lengthy question.
Okay.
Oh, go ahead. Mine, it's not popping up. So if you're getting them faster than me, it might be better for you to read it.
No, I'm not getting anything from... Do you want to go back to Bobby's question while we wait for Gail's? There was a question there.
Okay, so that was related to...
It was related, it wasn't on the topic of consent to treatment. I don't know if you want to address it, Brendan. The lawyer refused to assist a client with changing his will, and the client's wife were at a loss how to get the lawyer to reconsider presumption of incapacity.
So when it comes to making a will, a person has to have what's called testamentary capacity. And in a nutshell, what that really speaks to is, you've got the themes of understand and appreciate there, but it's with regards to matters related to your will. As I mentioned kind of earlier in the presentation, a lawyer a lawyer, it's a lawyer's role to ensure that the individual meets those legislative thresholds before proceeding to provide advice related to the drafting of a will. If the lawyer doesn't feel that the person meets those capacity thresholds, then the lawyer's not going to move forward.
Okay.
Yeah,
Okay.
but I mean, it doesn't stop the individual from going and seeing another lawyer and having going through the process again with another lawyer.
So let's Gail's question here, because I want to keep it focused on the topic of consent to treatment. Gail says, I'm concerned about the lack of training for healthcare professionals. Although Brendan is saying that capacity should be presumed, I think the opposite is often presumed for people with speech language disabilities. What do you suggest? I agree totally. I think we've been saying that all the way through, that the context is a major problem. We need to educate healthcare professionals, but not only educate healthcare professionals. I think we need a protocol that is distinct for people, a protocol for consent to treatment that is distinct for people with speech and language disabilities as a unique population, and that protocol must put in place, as we suggest, the supports that they require. But we also cannot just say it's about healthcare professionals if speech language pathologists aren't able to come in and assist in that situation. So I think that there's a lot of pieces to this puzzle that need to be pulled together. The fact that it is very serious, it is, Gail, and we have to do something about it. We need to be training the consent capacity boards. We need to be training doctors in healthcare in healthcare settings, but we also need to be, as speech pathologists, supporting our clients, the people with speech and language disabilities themselves. Sorry, Brendan, I jumped in there. I read the question and answered it. I turn it over to you and to Megan.
No, that's okay. Yeah, I don't think I've got anything to add there. So, thank you.
I think the only thing I would add is that for many healthcare providers, this situation is something that they don't encounter very frequently, and in their training and the pre-existing template that they have in their head for consent and capacity and how they handle these situations doesn't include this sort of scenario, because they encounter patients like this very rarely in their regular practice for most specialists or most doctors. So I think Barbara's right in the sense that we can train the healthcare providers, but I think that even when you do that, if it's not a scenario that comes up frequently in practice for people, the implementation or the rollout of that is going to be spotty in terms of how they'll respond in the immediate circumstance. And I think if there are more resources that people can access, just the same way you would if you realize that someone's English is a second language and you call up interpreter services, or you recognize that you need something else or someone else to help you, I think the more support we can have, or the more we can have protocols in place, I think that will help healthcare providers to feel more comfortable and confident in sort of handling the circumstance more appropriately. If that
Any more questions?
answers that question.
Thanks, Megan. Thank you.
My computer is frozen.
I don't see any more
My
questions.
chat is frozen.
Okay, I'll talk it through. I've got no more questions coming, and if that's it, we'll say good night. I want to tell you about next week. We're getting together again on May 25th at 7 o'clock, and it's going to be about substitute decision making, and I'm really looking forward to that. Thank you all. Good night. Have a lovely long weekend, and hopefully you'll connect in with us next Wednesday. Thanks, everyone.